Hi friends, this is CMA Deepika Bhugra Prasad. I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements. So today we will discuss an important case under the SARFAESI Act, as both IBC and SARFAESI together are playing a pivotal role in reshaping the economic landscape in our country. So let us discuss this case today. So friends, this is the case of Central Bank of India versus Shanmugavelu, wherein the Supreme Court's ruling on earnest money forfeiture under the SARFAESI rules. This was decided on 2nd of February 2024 by the Honorable Supreme Court of India. So in a recent landmark decision, the Honorable Supreme Court of India has upheld the validity of Rule 9, Sub-Rule 5 of SARFAESI rules, which empowers secured creditors to forfeit earnest money deposits. The case emerged from a dispute involving a nationalized bank and Best and Crompton engineering projects. The bank had extended credit facilities to the company, securing it against a parcel of land in Chennai. Following a default, the bank seized the property for auction under the SARFAESI Act. Now, pursuant to a public auction conducted by the bank, the respondent emerged as the highest bidder at Rs 12.27 crores, but failed to pay the balance within the stipulated time, leading to forfeiture. Now, let us see what is the factual background of the case. The Central Bank of India had sanctioned credit facilities to Best and Crompton engineering projects against a parcel of land with superstructures, a security interest in the form of a simple mortgage in lieu of the sanctioned credit. Thereafter, the said borrowers defaulted, and the loan account was classified as an NPA by the bank. Now, to recover its dues, the bank took measures under Section 13, Subsection 4 of the SARFAESI Act 2002 by taking over the possession of the secured asset and putting the sale for sale by way of a public auction. Accordingly, an e-auction notice for the sale of secured asset at a reserve price was issued by the bank. 4 bids were received, where the respondent also participated and submitted its highest bid, and he was declared the successful auction purchaser. Thereafter, the respondent on the same day deposited 25% of the bid amount as the EMD, upon which the bank confirmed the sale of the secured asset in favor of the respondent, while its letter, which stipulated that in the event of default in payment of the balance amount, the sale shall be liable to be cancelled and the earnest money would be forfeited. The respondent, being unable to pay the balance amount within the period, sought an additional 15 days to make the balance payment. However, the bank turned down the said request for extension and intimated the respondent that due to its failure in remitting the balance amount within the stipulated time, the sale is cancelled and the amount already deposited stands forfeited. Now let us see what are the observations of the courts. The Honorable High Court in the instant case held that forfeiture of the entire deposit under Rule 9, Sub-Rule 5 of the SARFAESI rules by the appellant bank, after having recovered its dues from the subsequent sale, amounts to unjust enrichment, and that Section 73 of the 1872 Act will be applicable, and any forfeiture will only be allowed to the extent of the loss or damage suffered by the secured creditor. However, the Honorable Supreme Court has held that the entire earnest money deposited by an auction purchaser would be forfeited as per Rule 9, Sub-Rule 5 of the SARFAESI rules on the failure to deposit the remaining amount within the stipulated period. The central issues before the Honorable Supreme Court were twofold. Firstly, whether the forfeiture of the entire earnest money deposit was justifiable under Rule 9(5) of the SARFAESI rules. And secondly, whether Section 73 and 74 of the Indian Contract Act had any applicability in this context. Now let us understand forfeiture under the SARFAESI rules. The court said that the legislator, through Rule 9(5) of the SARFAESI rules, has made a conscious departure from the general law by statutorily providing for the forfeiture of earnest money deposit of the successful auction purchaser for its failure in depositing the balance consideration within the statutory period. The forfeiture is a result of a breach of obligation, but the consequence of forfeiture in such a case is taking place not because of the breach, but because of the operation of the statutory provision providing for forfeiture that is attracted because of the breach. Any dilution of the forfeiture provided under Rule 9, Sub-Rule 5 of the SARFAESI rules would result in the entire auction process under SARFAESI Act being disregarded by mischievous auction purchasers through sham bids, thereby undermining the overall object of the Act of promoting financial stability, reducing NPAs, and fostering a more efficient and streamlined mechanism for recovery of bad debts. Now let us understand the applicability of Sections 73 and 74. The Honorable Supreme Court, in its wisdom, held that the Madras High Court had erred by considering the forfeiture unjust enrichment. It emphasized that Sections 73 and 74 of the Indian Contract Act have no bearing on the forfeiture of earnest money deposits under Rule 9, Sub-Rule 5 of the SARFAESI rules. It added that if the consequence of forfeiture was purely a matter of breach of contract, then there would have been no occasion for the legislature to specifically provide for forfeiture through the statutory provisions, and it would have been simpliciter relegated the consequences of such breach to already existing general law under Section 73 and 74 of the 1872 Act. So, friends, we conclude that this judgment reinforces the legislative intent behind Rule 9.5 of the SARFAESI rules. It recognizes the necessity of the forfeiture provision to streamline the resolution of bad debts and promote financial stability. The court's decision underscores that the courts should be cautious in reading down provisions, especially when their plain meaning is clear and valid. Further, it has emphasized that a law or a rule should be beneficial in the sense that it should suppress the mischief and advance the remedy. So, friends, we see here that the courts have delivered a judgment towards contribution to the creation of a more investor-friendly India, leading to a $5 trillion economy as envisioned by our Honorable Prime Minister. So, friends, I trust that you find this both engaging as well as enlightening. For further insights, please like this video and subscribe to my YouTube channel. So, friends, this is Deepika B. Prasad signing off. Thank you for being with me here today. We'll catch you in the next case. Thank you.